Let's look at a few bullet points of what we'll learn in this session. The nuisance of overlooking. That's the firm and trustees of the Tate Gallery, the Tate peeping case. Nuisance in the office, clients and other staff members. The nuisance of Japanese knotweed, liability and compensation, and going a little further, the nuisance caused by trees and their roots. Landlord and tenant, what is meant by quiet enjoyment and how can nuisance reach that. Noise, the Perez case. Interaction between nuisance and planning permission. What can constitute a breach of a covenant against nuisance and annoyance. Neighbours' works, often problematic. An interference, say, with TV signal as a nuisance. Animals, physical condition and waste accumulation. Easements. When can interference with an easement constitute nuisance, and how might the courts assess this in monetary terms? Does the Human Rights Act have any application to our topic of nuisance today? We'll look at some examples of use of land that has constituted action nuisance from time to time. Another example in the context of rights to light, some of the leading cases, and the Supreme Court decision in Coventry and Lawrence. Let's examine the interaction now between nuisance and planning law. Case involved this was Forster and the Secretary of State for Communities and Local Government, Court of Appeal. It concerned planning law and an unusual agreement, or argument rather, regarding potential future nuisance. The claimant said a decision to grant planning permission to a neighbour meant that it was she herself who might one day in the future be found liable in nuisance to that neighbour. Miss Forster owned a pub and operated it as a nightclub with live music, weekends open until 3 a.m. Planning permission was granted to a developer to demolish a single-storey building next door and build a 3-storey commercial building and 6 residential flats above, all objected to by Miss Forster, based on the possibility that Miss Forster might be subject to complaints by future residents of flats regarding noise from the pub. She argued there was quite a heavy risk of that. Now, it's no defence to a claim of nuisance that the claimant owned to the nuisance. In other words, that the defendant was there first. So Miss Forster anticipated correctly that if she were sued in the future for nuisance caused by noise emanating from a nightclub and late night music sessions, it would simply be no answer for her to say that she was operating her business there first. But on those grounds, she failed, not on the principle, which was accepted by the court, but simply by her lack of compelling evidence to substantiate her fears. So she had a good case, but not good enough, and she didn't win.